Hello there. I am Glennetta Haymon with Haymon Law Office, where we protect your brand, your business, and your family. What we do here at Haymon Law Office is we provide information to small business owners and entrepreneurs about how really to protect their brand when they're building their small business. So that involves business law, copyright, and trademark. Now today I am going to talk to you about a post-registration filing called the Section 7 Request to Amend. I'm going to tell you what that is, what that's about, and when you need to do it. So if you have a registered trademark and you're wondering about the Section 7 Request to Amend, stay tuned. I'm going to provide you with some information about this very important registration filing. So let's hop right in. The Section 7 Request to Amend is a post-registration filing. So what that means, if you are on the primary registry, not the supplemental, then you can amend your trademark in your registration to agree with the trademark that's currently in use. So if you have minor changes from your initial application when you applied for your trademark was approved, and you have minor changes to that trademark, you may want to let the USPTO know that you have those minor changes, so when it's time for the post-registration filings, you don't have any issues. So if you've undergone a brand change in the time since you've registered your trademark, up until now, or whenever you realize that you have a brand change and your trademark, the one that's registered, has changed, I would advise that you consult with your trademark attorney to ensure that the change on your particular trademark is minor and not material. Because if it's a material change, if it's a material alteration, there may not be an opportunity for you to obtain a Section 7 request to amend. So if it's vastly different, if the mark is vastly different, you may want to start all over with a new trademark identifying the correct trademark on your brand. So say, for example, you have a mark with particular wording and you remove one of the words. Say the word was Sadler Rail, and you want to take off rail. Now this was an example provided by the USPTO. It's the first thing that came to my mind because I watch a lot of their seminars. But if you remove the rail, the term rail is generic in its terms for that particular good because Sadler is their brand. Rail was just something generic that they added onto it. And then later on, they removed the rail and they wanted to keep Sadler. It was the same font, no other changes, just a removal. That may be okay for the USPTO. They may accept your Section 7 request to amend in that instance because rail is generic in terms of the goods sold. Now, if you have something that causes a material alteration, say Susie's backpacks, and you want to remove backpacks and you're still selling backpacks, that may not be accepted with the USPTO because that is a material alteration identifying the goods that you sell. So, in essence, I recommend you talk to a trademark attorney if you have questions about whether or not you should file your Section 7 request to amend. Again, anytime that you have minor changes that you're making to your trademark that's already registered, you want to go ahead and file the request to amend. So when it's time for subsequent post-registration filings between the 5th and 6th year and the 9th and 10th year, you won't be submitting a specimen that looks totally different than your registered mark. You want to be proactive and do that up front. So if you have any questions about that, please feel free to reach out to us. Again, we are a business law, trademark, and copyright law firm here to serve you and provide you with resources. Again, my name is Glennetta Haymon with Haymon Law Office, and I hope to hear from you soon. If you have questions, feel free to book a discovery call. They are free, our 15-minute discovery calls, so we can see how to best serve you. Take care. Have a great day.